Let's go on the record on cause number DC 1717249. Elizabeth Martinez versus Al Pisano Northwest Highway, Inc. Council, make your appearances.
Your Honor, Michael Pema, the movement representing El Paisano Northwest Highway, Inc.
Ori Raphael on behalf of the plaintiff, Ms. Martinez, Your Honor.
Let's proceed.
If I may proceed, Your Honor, I'm sure the court remembers we had a bench trial on December 8th, and the court announced its verdict on December the 15th. We filed a motion for new trial when you signed the February, I believe February 1 or February 2 initial final judgment. What happened when we filed our motion for new trial is that we asked the court for some clarifications or corrections rather. What happened was your verdict was that El Paisano was 50% at fault, Tovar was 50% at fault, and the plaintiff was 25% at fault. So
those numbers don't work out.
You said 50.
I'm sorry, 50, 25, 25.
Okay.
I'm sorry. May I share my screen? Because then there's some numbers I'd like to show the court.
Go ahead.
Basically, the court awarded, I don't know, it doesn't come up, but the court awarded a total of $78,396.01.
Yeah.
That was included $2,500 for disfigurement. When we had our last motion for new trial, and I believe you were doing.
I thought we already had a hearing on this. I thought I already corrected this.
You did, Your Honor. And what happened was the new judgment that was submitted to you did not have that $2,500 deducted from it. So that's one element that we bring up to the court again, because that $2,500 was not deducted from the judgment, even though you did make a ruling that that $2,500 should be struck. And I'll let Mr. Raphael, if he wants to respond to that, whether he agrees or not.
No, Your Honor, when we had that hearing, it was about the 25% on the judgment, which we changed it. The court signed it back in April. The 2,500, it's actually not in the record, and Mr. Payman has never brought up any evidence or made any objections at trial to that for that $2,500 he's talking about for disfigurement. I mean, it is in the record. So yeah, I don't see why he's saying it needs to be taken off. That was not agreed to, actually. It was only the 25% for the full judgment.
Your Honor, I believe the court agreed that it should be taken out. I think the court remembers correctly that you ordered that $2,500 to be deducted.
To be honest, I don't remember. You said that I did, so I was taking you at your word, but I don't remember one way or the other what I did.
Right. Well, I can argue that again if the court wants to, because
I don't. I mean, I kind of feel the judgment is the judgment at this point. What I corrected the 20. What did I correct exactly? The 25%.
You corrected the percentages because the initial judgment was for the total amount, whereas it did not have the 25% to Ms. Martinez.
Okay, and we corrected that.
You corrected that through your amended judgment.
Okay.
The other issue that I wanted to, I mean, do you want to hear argument on the $2,500?
No, I mean, if you guys don't agree, then I kind of think it is what it is.
So you're going to keep the $2,500 disfigurement in there?
Unless there's an agreement.
All right, that's fine, Judge. There is no agreement, but, and I think you were in your car. I think your wife was having some procedure, so I don't think there was a Zoom. There was a YouTube. I tried to look for
YouTube. Yeah. Okay. Yeah.
So if you
I mean, one of our problems right now is we don't have an associate judge. We've been waiting for 7 months, and so that's causing some problems. I felt bad I had to handle it that way, but either I was going to have to cancel my docket. I usually would have assigned that to the associate judge, but we don't have an associate judge. So should I move away from the disfigurement? You're going to keep it there? Sure. Yeah.
The next issue that I raised, Judge, was I guess the numbers. I believe the judgment, when you have two parties under vicarious liability, there should be X number assigned. 50% of your judgment should be awarded to El Paisano. 25% should be assigned to Frank Tovar, and then a finding that El Paisano is jointly and severally or liable vicariously. I believe the way that you have the judgment written, it does not mention Tovar, because even though Tovar was found 25% liable, I think the proper format would be for the court to find this much against El Paisano, this dollar amount against Tovar, and then a paragraph that says the court finds El Paisano vicariously liable. I believe the judgment itself is just a boilerplate, this much against El Paisano, and I think that judgment is improper on its face.
Mr. Raphael, do you agree?
No, Your Honor, I do not. And there is a signed findings of fact and conclusion of law on this case, also signed, I think, on March 5th, 2021. Your Honor, Mr. Payne is going to just keep trying to poke holes in everything he can on this case. I mean, he's made it very clear he's going to appeal no matter what. We're just going to keep going through this roundabout. I don't know if the court still has plenary power, frankly, but we had the trial. They didn't object during trial with all these issues. Nothing new in this motion. We've already had this motion 2 months ago or 3 months ago, I believe, and it's becoming frivolous at this point, Your Honor.
May I proceed, Your Honor?
Okay.
It's your call, but the other issue that I have, if the court does not want to break them up, is that there is a $1,249.59 that has been awarded twice. Once it has been awarded as taxable court costs, because that's the cost associated with the deposition and the translation fee. And that was awarded to Mr. Raphael in form of sanctions, clearly for the cost of the deposition. And it's also added to the taxable court costs. So I believe the numbers, he should only get that deposition fee and the translation fee one time. So the way that I had it figured out, if I may show the court, is either keep it on the sanctions aspect, what I had to pay for that, or keep it on taxable court costs. So I believe the taxable court cost then should be reduced by that amount to $2,520.42, because we're getting that twice.
Your Honor, if I may.
Yeah.
I've already had this discussion with Mr. Pema a while ago. One of them, the sanctions was for the witness that they hid for a few months. The other portion of the translation fee was for his own client who lied under oath, not knowing where that witness was, who they were suing at that same time. So it was 2 translation fees. I've showed it to him in that same deposition fee. One's in the sanctions, one's in the cost of court. It's 2 different depositions he's referring to, and I've talked to him about it already, Your Honor.
I got an email from Mr. Raphael that I asked him, where do you get the taxable court costs? And he told me that this is what the taxable court cost is. I looked at the email earlier today, and it included $1,249 for the deposition of the 2 clients of mine, the court rep and the owner. And those are the same amount that's reflected in the sanction. And it's also added. If I'm wrong in the math, Mr. Raphael, I would love to see what you have. And
I don't need to present the evidence. You're the one showing. I don't understand every time. This is the second time we've had this hearing, and I am the one who has to present evidence each time. It's his motion for new trial. He didn't object to it the first time. I don't know why he's doing this again now. This is the second time we've had this hearing, Your Honor. And we did this actually after trial. We had actually 3 or 2 more days of going through the same roundabout after the judgment was rendered in the trial.
Your Honor, my job as an attorney is to present the errors that I see to the court, preserve errors on behalf of my client, and try to obtain a judgment that complies with the law and the ruling of the court. And every time, if the court signs an order that is not in compliance with the court rendered or does not follow the law, it's my obligation to raise it. That's all I'm doing. I don't know why Mr. Raphael gets frustrated, but I believe as an attorney, I'm obligated to do what's best for my client under the law.
All right, that's denied. Anything else, Mr. Payman?
Your Honor, the last issue I wanted to raise was that you made finding on 3 elements, 3 causes of action, I believe negligence, assault, and false imprisonment. The judgment does not reflect, even though the same amount was awarded in same percentages, I believe under the law, he has to elect one. You can't just say, is it on all 3, or is it on 1, is it on 2, or which one it is? So I think I'm entitled, for purpose of appeal, to know which finding he has chosen, where I can address my issues to the Court of Appeals on that element or that cause of action, rather than not knowing which element he has elected. He has the right to elect whichever one he wants. And I have no problem with that. That's his right. But you cannot just have a finding by a jury on 4 or 5 different elements and then not telling me which one he's proceeding under, or which cause of action he's obtaining a judgment under.
Response?
I don't know what rule he's doing that under. I mean, he's saying he believes, but I don't know what the specific rule he's implying, Your Honor. Plus, he does agree negligence is the claim that the case was under. I'm pulling up the judgment now, Your Honor, one moment. And I know Mr. Pema did agree that negligence was the finding. And then also there's a findings of fact of conclusion of law, which they did a motion for a signed findings of fact conclusion of law, but there is one. But it is based off negligence. I mean, I don't know what else he's requesting, what other changes he wants to keep making to buy time. I mean,
Your Honor, is it my understanding, and are we on the record, just so that I can have something to, I don't want to appeal something on negligence and then have Mr. Raphael say, well, that's not the one I went under false imprisonment. So,
Your Honor, I don't know why he's trying to
I
put
mean,
me on.
he is right. There might eventually be a Castile issue, but I think you can proceed under more than one. So, and as long as you had separate findings on each, I think that should resolve the Castile issue. But I mean, Mr. Raphael, if you wanted to change, we can change it. If you don't, I'll go ahead and deny it.
No, Your Honor, I do not want to change it.
I mean, I would possibly talk to an appellate attorney about it just to see if there's a Castile issue, but that's your call. Anything else?
no, Your Honor.
Thank you, guys. You guys be safe. Good to see you again. I hope everything's going well.
Thank you, Your
sir.
Honor.
You too.
Have a great day.
You guys.
Bye-bye.
I think our next hearing is on the Brylowski versus Brylowski case. Is that right? Mr. Bennett, are you here for that?
Yes, Your Honor. I represent the defendant, Maureen McAndrew.
Okay. You don't represent Miss Brylowski?
I do not, no, Your Honor. That's Mr. That's Mr. Stuckey, Skylar Stuckey.
Oh, I have him down representing the plaintiff. Is that not right?
Right. He represents the plaintiff, Dr. Brylowski.
Okay, and then okay.
I'm sorry, and I represent Miss McAndrew. She's the defendant.
Oh, it says here that Jennifer Brylowski is the defendant. Is that not right?
She was one of the defendants originally, and I think she's recently been non-suited.
Okay. Sounds good. And you expect there's Mr. Stuckey. He's just signing on now. Mr. Stuckey, can you hear us?
Yes, Your Honor.
Okay, are you guys ready to get started?
Yes, Your Honor.
All right, you guys are set for trial next month. We could actually go to trial that day. I think we have my date is the 19th. We'd have to move it up a day, but I think we could actually go to trial next month, at least potentially. So, kind of tell me what the concern is about going to trial now.
Well, Your Honor, I'll try to briefly explain. We initially filed this suit with several other defendants involved. We spent, I want to say, 6 to 7 months negotiating settlements with those defendants and getting them dismissed from the case. The case has, I guess, the focus of the case is now turned to the claims remaining against only Miss McAndrew, who Mr. Bennett represents. Mr. Bennett and I have been in discussions about discovery. In this case, getting some depositions scheduled. Miss McAndrew is located in Chicago. COVID obviously made things hard for everybody, which everybody understands. That's not unique to us, but everybody understands. We have exchanged initial discovery in this case. We filed a motion for protective order last week to get additional discovery exchanged between us, and are working on setting up depositions and discussing mediation as well. I think this is a case that may be resolvable without trial necessary, and the agreed order, or sorry, the proposed agreed continuance was sort of designed with in mind taking the necessary discovery to determine if we can resolve this case. I think if we had to go to trial next month, it would be pretty difficult, but we could do it if that's the court's necessitation. I think the agreed order between Mr. Bennett and I, my understanding is just to give the parties time to really focus on the amended petition that we filed earlier this month that refocuses the claims on Ms. McAndrew, presents a new claim for professional malpractice, which we're working on getting an expert lined up on. And because of the way the case initially was filed, with defendants then being removed and being refocused, while it has been on file for a while, the case is in a little bit different stance than it was in 2020. So I think the additional time would allow Mr. Bennett and I time to figure out if we can wrap this case up without the need for the court's time, but also would give the clients time to analyze the new stance of the case.
Response?
Your Honor, I would just echo what Mr. Stuckey is saying. When the case was originally filed, as the court noted, Ms. Brylowski was a defendant, several other folks were as well. They've just recently filed an amended petition, which makes a number of new allegations. So, I'd like an opportunity to discuss those with my folks, do some of the discovery we've been talking about, and hopefully get the case into mediation and see if it could be resolved. And, obviously if it can't, then we'd like to, be before the court when we're all ready and the court could, have a streamlined trial without a lot of motion practice and things. It's probably just not necessary. So we would just respectfully ask that the court grant the continuance.
Okay, so you're asking for February 28th. That's a Monday. We usually start trials on a Tuesday, so that would be March 1st. Do you really feel like you need that much time, or?
I feel like I'd hate to have to come back and ask the court for more time. That's my thinking, is to ask for a time when we think we can actually be ready.
Okay, thank you. All right, we'll go ahead and reset it to March 1st of next year. Thank you. You guys, see if you can try to get this done, and we'll see you on the next one, okay?
All right, thank you, Your Honor.
Thank you very much, Your Honor.